All right, good morning and welcome to the District of Columbia Court of Appeals. We have two matters set for argument this morning. The first case is John Doe versus United States. I would like to note that I'm joined this morning by Judge Anthony Epstein, who's sitting by designation from the DC Superior Court, and Associate Judge Vijay Shankar, who is joining us virtually for this oral argument. Before we begin, I would note that in the matter of John Doe versus United States, appellants filed a motion yesterday evening seeking the recusal of Judge Epstein. The United States opposed the motion but declined to file anything. Judge Epstein has determined that he will not recuse, so we'll go forward with oral argument at this time.
Thank you.
Good morning.
Good morning. May it please the court. Michael Meredith Weidman on behalf of appellant John Doe. I'd like to reserve 3 minutes for rebuttal today.
Thank you.
IRA does not permit a judge to decide, especially on a record like this, that someone like Mr. Doe deserves to remain in prison despite his rehabilitation because the judge believes his offenses and the harm he caused were among the most serious. Factually, Mr. Doe's offenses and the harm he caused were just what the council was thinking of when it enacted IRA and determined that young people are categorically less culpable than adults because they're still maturing. Mr. Doe was...
Ms. Michael, I always reverse your name. I apologize, counsel. Ms. Weidman. Here, the judge did reduce the sentence significantly. And so tell me what the harm was in your view here, where she did, in accordance with her analysis of IRA, ultimately reduce the sentence quite significantly, I think by how many years? 15 years off the ultimate sentence. What is the I guess, crux of your concern with either how the analysis was done or the extent to which the sentence was reduced?
So I think that the crux of our argument is that the judge's decision in this case rested entirely on the nature of the offense and the harm to the victims, which we think are sort of flip sides of the same coin. And that was a retributive analysis, which we think IRA takes out of the calculus.
But didn't she walk through pretty explicitly almost all, if not all, 10, 11 of the IRA elements in her discussion? And she walked through those and then turned to a more general assessment as well. I guess, does her general statement about the seriousness of the offense negate all that she said about each of the other IRA elements that she was required to consider?
I don't know that I would put it in terms of negating. I think that her analysis of the other IRA factors was all in Mr. Doe's favor. She found that he is no longer dangerous. She found that he has been rehabilitated. She praised his programming efforts. And I think her ruling is clear that the only reason that she didn't release him immediately, and I will point out too that this was a case where the government did not oppose immediate release, or she departed from the government's own assessment of this case. The only reason she didn't go along with that was because she believed that this offense was among the most severe and the harm to the victims was among the most severe. And that's a retribution analysis about what a certain crime deserves. And
so, counsel, you would agree that partial relief is permitted under the IRA?
Yes, Your Honor. I'm sorry.
Is that or only under IRA generally that it must be immediate release in all cases?
So the statute contemplates a partial grant, but we think that the council was certainly contemplating that release was going to be the outcome in these cases. We know that from the legislative history, where they talk about how in both the committee reports, when the statute was amended in 2018 and then again in 2020, they talk about how as a practical matter, people who were being, whose motions were granted were being released immediately. They approved of that. And I think, we know that this is a statute that is about release generally because of the statutory purpose to grant a meaningful opportunity for release based on demonstrated rehabilitation and maturation, and also the twin purpose of reducing incarceration and responding to the problem of the costs that come with keeping people in prison past the point of rehabilitation. The statute does contemplate a partial grant, but it also makes a partial grant appealable, which I think is a very strong indication that merely reducing a sentence and not releasing someone outright is not a full grant under IRA.
Clearly, the trial court relied on the seriousness of the offense was an important factor. Bishop seems to say that it's okay to consider it. You can't give undue weight to it, but it's okay. Would you agree that Bishop validates the trial court's decision to consider the seriousness of the offense?
I think that Bishop validates the consideration of the nature of the offense insofar as it relates to permissible analyses under the statute, such as rehabilitation, the role in the offense, a baseline for evaluating how someone has matured. I think that Bishop does not stand for, and I think actually the rest of Bishop's language in that passage of dicta at the end, in fact, indicate all the ways the council has taken a particular purpose, retribution, off the table as a potential use for the nature of the offense. And those are the four factors that Bishop identifies from the legislative history and the statutory amendments.
Is your answer the same with respect to Welch and the impact of the offense on the victims?
Yes, I think so. I think, and I'll say in both of those cases, both in Bishop and in Welch, these are passing references in dicta, right? In neither of those cases was the court analyzing the question presented here, which is, using the nature of the offense and the harm to victims for a very particular purpose, which is the judge's determination that because of those things, they were so serious, this particular individual deserves to spend more time in prison, which we think is absolutely counter to the entire enterprise of IRA.
So then what role does the interest of justice prong play? If the defendant's eligible because they were less than 25 when they committed the offense, they've served more than 15 years in prison, they proved they're rehabilitated, under your argument, there's no separate content to the interest of justice prong. It has to be in the interest of justice to release that person immediately, or am I missing something?
So I think that we conceive, based on the statutory purpose of the interest of justice being a rehabilitative analysis that is broader than dangerousness. We think that danger, you can be someone who might not be at imminent risk of harming someone or committing a crime, but still not meet the standard of maturity and rehabilitation that the statute is looking for. You have not demonstrated you're really a completely changed person. However, I will say, to the degree that the government thinks there's more in the interests of justice analysis, what we have here is very firm indications over and over again from the council saying that the one thing that can't be in it is retribution, because IRA is not like a regular sentencing statute. This is a completely different scheme that is designed to solve a very particular problem of initially children, but now all young people who did very serious things when they were young. They've served a very long time in prison and they're now rehabilitated. They're different people. And the statute is designed it mandates, Factor 10 mandates that the hallmark features of youth and diminished culpability of these offenders, these young people, mitigates against, disfavors lengthy sentences, no matter what. And even for cold-blooded and brutal offenses, it specifically—
Counsel, would you agree? If the statute contemplates a two-step framework, so reduce the sentence, grant the motion, or partially grant the motion, and then proceed to resentencing, which subsection E seems to contemplate, that in a true resentencing, the nature of the offense can be considered in its entirety? Or would you say that resentencing, even if it's a second step, has to be done within the context or the spirit or the purpose of IRA?
We think it needs to be done within the spirit and purpose of IRA. We think that IRA is a self-contained sentencing scheme designed to solve a very specific problem. We think that there's no basis, and I think that our reply brief it points to the legislative history behind subsection E's reference to the other statutory sections, and that was purely to solve an ex post facto clause problem because the initial draft of this legislation required judges to impose a period of supervised release, no matter what sentencing scheme the person had been sentenced under originally, and that would have caused a problem. So they took that out and said, you need to have the same type of sentence imposed.
Well, I realize that might be the explanation for the reference to the 3 statutes, but the statute does use the term resentencing. And in, other subsections, it seems to contemplate a separate second proceeding. That's where I'm hung up.
So I think that if you compare this to other statutes, especially other sentencing statutes, I think the compassionate release statute is a good comparator here. One thing that counsel didn't do here, quite deliberately, was they didn't include any cross references to other statutory factors, right? There's no instruction in this case that the sentencing, that the decision about what sentence to impose should be guided by factors set out in any other sentencing scheme. And I think the other thing it doesn't do is, the other thing it does is it enumerates a very long list of factors that the judges do need to consider. And I think, and we also, on top of that, have the legislative history showing all of the efforts and the changes to the statute, all of the efforts.
So here, I know you have voices coming from all directions. Here, what the trial judge did pretty methodically was to walk through the factors in the IRA statute and assess them, and then take a look. She cites to 3-101, and that is where she begins to generally talk about other resentencing principles. So your argument is that if she had just stopped after walking through the enumerated factors under the IRA statute, and then concluded that a significant reduction, and I try to do the math in my head, but by nearly 15 years, I believe.
22, I think.
22 years, I keep saying, off of his original extensive sentencing was appropriate, that would have been fine?
No, Your Honor, no. Our first argument is, yes, one of our arguments is that it's error to look outside of IRA to other sentencing schemes, because IRA explains exactly what judges need to take into account in making the sentencing decision. We know that from Brian Williams. We know that from the legislative history.
IRA does reference the determinate sentencing provisions or indeterminate sentencing provisions under which they were originally sentenced.
But we think, and the legislative history makes very clear, that that language is put in there purely to make sure that we have a legal sentence imposed, because IRA is going to encompass people who are sentenced under different types of sentencing regimes. Some are under the indeterminate scheme, some are under the determinate scheme, and it would present a problem to sentence one under the other scheme. So that has a very targeted purpose. And I think that our primary argument is it's really clear that the council took certain things off the table when it comes to IRA. And so our argument is that even if the judge had not cited 3-101, by saying I am deciding that I'm not going to follow the government's unopposed concession that immediate release is appropriate, purely because of the nature of the offense and the harm to victims, the judge is relying on a factor that
does she say that? That's what I'm trying to get at by the fact that she walked through a number of the enumerated factors under IRA, some of which inherently are get to the nature of the original offense. Maybe they don't call it that. They don't solely focus on that. And so it seems like that is woven into an entire mosaic of these factors. And so is the error that she simply said it out loud, even though she did actually walk through and consider these other things? Or you're saying, you're suggesting that her saying it as she did after considering these other things, I guess I go back to my earlier word, negated her initial analysis of carefully walking through the IRA statutory factors.
I think that the record here and the judge's findings show that she found that Mr. Doe is not dangerous anymore and that he has been rehabilitated. And that, we believe, should have been the beginning and the end, and she should have released him at that point. The fact that she
The other
said,
piece of this, I know, it should have been the beginning and the end, but does it mean that she did find that he warranted his rehabilitation to the extent that she felt he was rehabilitated, did warrant a significant reduction in his sentence? Does that mean automatic release, though?
I think that on this record, that was the only option available to her, because the findings that she made about his rehabilitation and his non-dangerousness were the findings that IRA is calculated to have judges pursue. And the reason that she talks of, it's not just that she says the nature of the offense. It's very clear from the transcript of her oral ruling and the written ruling that she believes that based on the nature of the offense, he deserves to serve more time. She says that 26 years in prison is not enough for this type of offense.
But as this court has said, the purpose of sentencing is to find a punishment that fits the crime and the criminal. If the criminal is changed over time, then that requires another look at the sentence. But you said that the statute takes issues off the table. It has an interest of justice prong. It's hard to imagine something broader than the interest of justice. There's a factor 11 is a catch-all factor. Any other factor relevant to the interest of justice or non-dangerousness. Why is it so clear that the statute took off the table whether the reduced sentence is going to fit the crime?
I think that factor 10 is the best answer to that. And I think that the council's determination, not only to make this a mandatory factor, but also to add language specifically saying that diminished culpability of juveniles counsels against lengthy sentences, despite the brutality and cold-blooded nature of any particular crime.
But it doesn't say those factors mean that any sentence more than 15 years is unwarranted if the defendant no longer presents a danger to the community.
I think that what the council did in setting a uniform threshold of 15 years is to have made the determination that in IRA, and we see this from the legislative history, and writing a statute that otherwise is so focused on factors related to rehabilitation and maturity, they have decided as a legislative body whose prerogative it is to make sentencing policy, that 15 years is a lengthy sentence. And when you are talking about this particular special category of people who have inherently categorically diminished culpability, the flip side of that is retribution. Retribution and just desserts are all about culpability. The council has decided this is a category of people who are less culpable, and 15 years is enough time to assess what we care about. Are these people dangerous? Are they rehabilitated? Is there any reason to keep them in prison that justifies the added costs and the continued costs, the heavy social and financial costs of keeping rehabilitated people in prison past the point of rehabilitation? We think the council has spoken very affirmatively and said, no, that's not an appropriate determination for trial judges. The nature of the offense, even though the certain facts of the offense are going to necessarily have to be considered, you may not use the nature of the offense, the seriousness of the offense, in the way that other sentencing statutes use it. And that's what Factor 10 has said. I think that the language in Bishop has drawn that out very clearly. And I think that that is the landscape that this court should be interpreting the statute.
I have one final question. I believe it was in your reply brief where you suggest that if the trial judge here determined that immediate release was not appropriate, then there was a requirement that she explain that or justify that based on, I forgot the language that you used, but it seemed like you were suggesting an additional factor or additional standard for the trial judge to meet in addressing the obligations under the IRA statute for release or reduction of sentence.
I don't think we're suggesting any additional standard. I think that, our position here is on these facts. This was immediate release. This is a heartland IRA case, right? Mr. Doe is exactly who the Supreme Court was thinking of when it's thinking of Graham and Miller, and it's exactly who the council was thinking of. All of these facts left the judge, we think, with no basis to make any other decision. To the degree that there is ever a situation in an outlier case where a judge could potentially hold someone in prison for longer, there would need to be some, I think actually this points out one of the problems with introducing retribution is that it is not a measurable thing. It is very arbitrary. It's going to vary widely from judge to judge. And, unlike, a ruling saying there's a particular program I want you to be able to complete before I think you can be safely released, the judge's feelings about what a sufficient amount of time is to vindicate, victims' perspectives on things are not subject to calibration. And there's nothing in the statute that guides that. And we would think it's a basic judicial discretion principle that a judge needs to explain how they got from point A to point B. And on this record, we think as a matter of law, there is no justification for any other sentence. But I think it is also sort of a glaring absence of anything to say why this would be 6 more months versus 18 months versus 30 years. And I think that on the reading of the statute the government has proposed, those are the sorts of arbitrary rulings that would follow from departing from the very clear path that the council has imposed by writing the statute. And we think this court has imposed by interpreting it.
And I think your remedy from this court is immediate release and reversal, or remand for sentencing or reconsideration.
I think on this record and with these findings, it is so clear that this ruling is based solely on the nature of the offense and the harm to the victims, which is impermissible, that every other factual finding and record fact here, including the government's non-opposition, leaves the judge with only one option. So there's no basis to remand this for any further consideration. It should be remanded with instructions to grant immediate release for Mr. Doe.
All right. Thank you.
Thank you.
We'll reserve your time for a rebuttal.
Good morning, and may it please the court. Mark Hobel for the United States. And before I begin, I'd just like to take a brief moment to acknowledge the members of Ivy Phillips' family who are watching this argument this morning on live stream. They've maintained their strong interest in this proceeding. Let me begin just with the maybe one point that I agree with Ms. Weidman on, which is that these IRA determinations will vary widely from judge to judge. Judge Higashi carefully examined the record here, certainly took all of the factors that she was required to take into account under the IRA into account, and made an independent determination that she was going to reduce John Doe's sentence by a very, very significant amount, 22 years, but was not going to go the last mile and release him immediately. Instead, he'll be scheduled to be released, I believe, next summer. That was within the range of permissible choices available to Judge Higashi, and therefore she did not abuse her discretion. Let me turn now to the points that I disagree with Ms. Weidman on.
Counsel, can I ask you, how much of your argument then depends on what your brief seemed to suggest was a necessary argument for you, which is that this is a two-step process where we proceed to resentencing after granting in part the IRA motion? And let me go ahead and ask my second part of my question on that, which is, if it's a true resentencing separate and apart from the IRA scheme, then how would a partial grant ever be reviewable in this court? Because we generally don't review sentencings unless, for illegal reasons.
Right. So I think my answer to your first question is actually not much rides on this. And I realize that we fronted this point strongly in the brief because we think that the statute, strongly sets out a two-step process. Williams recognizes that if the judge determines a sentence should be reduced, the judge should proceed to resentencing. And frankly, during the sentencing proceeding itself, nobody said anything to suggest that they were confused as to why Judge Higashi was describing this as a two-step process. It's set out very clearly in the statute. But again, not a lot rides on this, because even if you focus only on subsection A and subsection C of the IRA, the interests of justice determination, as Welch recognizes, a holistic inquiry. It incorporates both the nature and seriousness of the offense and victim impact statements. It has to incorporate victim impact statements under subsection C6. And so, and as Judge Epstein, I believe, stated, it's a very broad inquiry. So even if Judge Higashi confined herself to the interests of justice standard, that section of her order is largely in harmony with the sentence on resentencing. She, in both places, she said, based on, weighing the factors that I need to weigh, the positive factors for John Doe versus the factors that caused me not to go the full distance here. He's entitled to a very, very significant reduction, but not to immediate release.
Wouldn't you agree that exactly the same factors are relevant to whether a sentence should be reduced at all as to by how much the sentence should be reduced? The appellant calls this kind of part and parcel of the same analysis. Why is that wrong?
I think the IRA did not displace the judge's general broad sentencing discretion, and the opinions that have come out this year, such as Bishop, such as Long, speak to the judge's substantial latitude, broad deference to the judge's sentencing determination. So, the context of the IRA and the factors that the judge is required to consider is tremendously important context. That's the reason that we're going through this proceeding. But it's not, the Williams described as resentencing in all but name, which incorporates a lot of discretion for the judge. So from that perspective, and the point I wanted to add, I'm sorry, is that I don't think you're going to see a lot of cases in which, and I think this is a good example, in which the judge's analysis under the interests of justice is going to vary very much is going to vary at all from the analysis under the fundamental analysis under the resentencing if they choose to approach it as a two-step, such as Judge Higashi did here.
But so I'm hard pressed to imagine any circumstances in which, the analysis would diverge. What factor is relevant to one to whether the sentence should be granted in whole or in part, and that's not relevant to what's the size of the sentence reduction?
I think that there are certain factors a judge has to take into account in determining whether a reduction is warranted under subsection A. On the other hand, in terms of what is off the table, and the defense has described certain factors as off the table, we entirely disagree. The interests of justice is broad, it's holistic. Subsection C11 makes clear the judge may consider any other information it deems relevant.
But didn't the council amend the IRA statute specifically to omit and take out the nature of the original offense language? And here, that seems to be what Judge Higashi ultimately focused her determination on, not to immediately release the appellant here.
Right. Well,
how do we reconcile those two? Was she going outside the IRA scheme in an impermissible way since the statute had been amended to address that very part, or was she conducting, as you say, a discretionary two-step resentencing?
So what this court has recognized in Bishop is that the amendments to the IRA took the nature of the offense off the table as a mandatory factor that the court has to consider. But it is still a permissible factor that the court may consider as part of the interests of justice. And while Bishop cautioned against over-reliance, I think it's important to look at Judge Higashi's resentencing decision, IRA decision, as a whole. This is not entirely focused on the nature of the offense and the impact of the victims, as John Doe has asserted, because if that were true, John Doe would not have received a 22-year sentence reduction. He would not have received more than 90% of the reduction that he asked for. The judge put much more weight in assessing the decision as a whole, which I think this court has to do. The judge put much more weight on his rehabilitation, his remorse, which are commendable, and the other mitigating circumstances. And that is why when we are not here discussing a denial of IRA relief, as in Bishop, as in Long, as in Henney. We are here discussing a judge's decision to go almost all of the way towards what the defendant wants, but not quite all the way.
I don't want to quibble with your math. I don't think it was over 90%. I think it was more like 75 or 80%, but be that as it may. Yeah. I mean, Bishop indicates, arguably in dictum, that the IRA judge can't give too much weight, can't over-rely on the circumstances of the offense. If that's right, how would you describe how much reliance is appropriate? Is it less reliance than the original sentencing judge can impose? If so, articulate what the difference is.
I think that the judge can give the nature of the nature and the seriousness of the offense as much weight as the judge thinks it deserves based on the record as a whole, evaluating the IRA factors with the type of review that this court has given. I realize that's a somewhat vague answer because all of these cases are going to be different. What I can say is with respect to this case, Judge Higashi did not over-rely on the nature of the offense. Judge Higashi, and again, I don't want to, math is not my strong suit, but when I said 90%, I was factoring in, she gave him a 22-year sentence reduction. I believe it would have been about a 23-and-a-half-year reduction he would have needed to get to immediate release. And so that's where I was getting the 90% from. But, that is, you can't look at that skew in terms of how much relief she gave him versus how much she held back. And we haven't even started discussing the victims at this point, because that is a factor that's mandatory. And think that she over-relied on. This court can't think it was unreasonable to put that extent, that she over-relied on in the way that Bishop cautioned against, in the way that the council was concerned about. The council in passing this legislation, I don't think this point should be controversial. They didn't pass this legislation to say everybody needs to get out now. I don't think that the council would have been concerned about a situation in which somebody who is deserving in a lot of ways, who is in a lot of ways in the heartland of this statute, is going to be released next summer when he's in his late 40s, I believe. But, that is the type of relief the council contemplated.
Well, I mean, I think the council may have contemplated that relief if somebody perhaps needed another 6 months of programming or hadn't, had a few lingering disciplinary infractions that the court wants to see. Are you going to be able to avoid those for another year? So I agree with you that the council didn't necessarily contemplate immediate release, but it seemed to tie that to the factors in IRA.
That's right. And those, the factors that you mentioned are all factors that the judge could rely on. And so are the factors here, including specifically the impact on the victims, which was so profound and which clearly had an effect. And I do want to just direct the court's attention to the record and to the statement of Ivy Phillips' daughter on in the December 12th transcript at 23. Ivy Phillips' daughter, who was 2 years old, I believe, when her mother was murdered and she was orphaned. She told the court, whatever decision that you make, hopefully is not immediate. Now, that was the impact. The impact on the victims was so profound here. And the trauma continued.
It wasn't so profound that it persuaded the government to oppose a sentence to time served. I mean, it was certainly, you can't dispute that it was within the range of reasonableness. And don't get me wrong, I'm not minimizing the lasting, permanent, horrible effect on the victims, but that can't preclude relief under IRA a reduction in the time served. And indeed, that was the government's position.
It's true enough that was our position, Your Honor, and our position was one of the factors, along with the victims, along with rehabilitation under subsection C that the judge had to consider. She made an independent determination, and she did not abuse her discretion in putting the amount of weight she did on the continuing trauma to the victims.
So, counsel, if we took out the nature and seriousness of the offense for a moment, under Welch, is it your position now that if a victim comes in and says, please don't release this defendant immediately, I think he or she should be in for another year, that standing alone would justify a partial grant, a reduction, save for a year?
I think that I think that the IRA directs courts that they need to consider that. That was an explicit, and so yes, I think that would be sufficient if the judge said, under the interests of justice, I am putting considerable weight on positive factors for the defendant and reducing the sentence to a great degree, but I'm not going to release immediately in deference to the victim impact statement, which I have to consider under subsection C6. I don't believe that this court could consider that to be an abuse of discretion. And I think Welch, and again, Welch and Bishop both have stated that the factors that Judge Higashi considered here, the nature of the offense and the victim impact statements, are considerations that can at the very least lessen or limit the reduction the defendant is entitled to under the interests of justice.
Sorry, counsel, can I ask one more question? This goes all the way back to earlier when I asked a two-part question, and I'm not sure you were able to get to the second part. So if this is a two-step process and it's a true resentencing, how would that be reviewable?
So I think that this court has already in Bishop and in Long to a great degree, and in Henney as well, demonstrated that there is there is review under the traditional abuse of discretion, which goes to, was there a legal error? Was there were there factual errors? Was this within the range of permissible decisions, while recognizing that this court still has broad deference? So the review is not toothless. We've seen this in Bishop, in Long, in Henney. This court has reversed where there's been an issue involving a legal question, a factual question, but we have not seen the case, and I don't think this is that case, where there was only one right outcome, as the defendant seems to think that there was, that release was the only option. Under this court's precedents and reviewing precedents, Judge Higashi considered the entire record. There's no indication of factual error. She didn't make a legal error, and she made an informed choice drawn from a firm factual foundation.
What about the appellant argues that she did make a legal error essentially by going outside the framework of the IRIS statute and looking at 3-101 and general sentencing principles and guidelines. Was that a legal error, or was that just a part of the deference that the child judge is allowed when looking at resentencing?
No, the judge followed the statute. She indicated that a significant reduction was warranted under subsection A, proceeded to resentence under subsection E. Under subsection E, she was required to resentence under the originally applicable sentencing regime, which was the old indeterminate sentencing regime, under which she had very broad discretion. If the offense had been committed here on or after August 5th, 2000, she would have had to resentence him under 24403.01, which lists a series of factors she would have had to have considered, including the seriousness of the offense, just punishment, deterrence. All those factors would have come into play. Under the old sentencing regime, she had such broad discretion. It's not surprising that she would have drawn on another source of traditional sentencing principles. In any event, the defendant's really not prejudiced by her reference to 3-101, even if it was wrong, because if the the judge's interest of justice analysis was largely in harmony with its sentencing determination. All those factors were factors that could have been considered under the interest of justice. And at the end of the day, that doesn't get John Doe what he wants, which is an order effectuating immediate release. At most, it would get him a remand for a new sentencing, at which Judge Higashi could impose the same sentence. And just one point, I'm sorry, before I sit down, Your Honors, I know my time is up, but I do want to address or just respond to the defense's point that the statute is really clear in precluding judges from relying on considerations like retribution. And it's really clear that it only is that subsection is only about what gets written on the JNC, that it's ministerial. You know, this is not, they're relying on legislative history to say that the statute is really clear about certain things, that in fact, at least on its face, it's clear in the opposite direction. It says the interests of justice. It says you can consider any other information it deems relevant. It says proceed to resentence under these provisions, which themselves describe how you resentence under those provisions. So the statute is not really clear in the way that I think the defense is trying to suggest that it is. So with that, unless the court has any additional questions for me, we would ask this court to affirm Judge Higashi's reasoned, careful decision.
All right, thank you. Ms. Weidman, you have a few minutes for rebuttal.
Thank you, Your Honor. I'd like to sort of, I think, focus on some language and decisions this court has already made about IRA. The first one being Brian Williams, which I think was, which is a 2019 opinion that was evaluating the statute as a whole, and it rejected the argument that IRA resentencings are this broad, mushy, discretionary sentencing, like a Rule 35 review of a sentence. That argument was made to the court, and the court rejected the argument that those two things are the same. It did displace broad discretion, the same broad discretion that the government is arguing applies here under its sort of convoluted reference to statutes that Mr. Doe was not even sentenced under. This court rejected an analogy to Rule 35, and it said, in response, in dispatching the defendant's argument that, you know, this is going to be basically unreviewable, the court said, absolutely not. It's reviewable for compliance with constitutional and other legal requirements. The IRA itself clearly sets forth a criteria that the court must consider. The enumerated factors in IRA are the things that distinguishes it from a parole hearing, distinguishes it from Rule 35, and distinguishes it from other sentences. And so this is highly reviewable, and that is, I think, point one.
Can I ask you a question before you go on to your next point on reviewable? When we review it, we're reviewing whether or not the trial judge adhered to these IRA factors under an abuse of discretion standard, right? And so in order to determine that the judge abused her discretion in how she reviewed or analyzed these factors, what do we look at? Do we have to find that her conclusions were clearly erroneous?
That she applied an incorrect legal principle in reaching her conclusion. And I think...
And that's your argument is that one outlying or overriding factor, depending on how you look at it, about whether or not she looked at the nature of the offense and sort of charged it as a retributive factor against the appellant.
We think that it was an error of law for the judge to decide that release was not appropriate because of the severity of the offense and the severity of the harm to the victims. And that brings me actually to the other two cases that I think that this case can be decided basically based by reference to these cases, which is Welch and Bishop. Bishop says, you know, when it walks through the legislative history, and not purely legislative history, these are amendments, this is statutory history, right? These are amendments to the statute. The council eliminated nature of the offense, added the language critically to factor 10 for the purpose of diminishing over-reliance on the nature of the offense to deny relief to rehabilitated people. The council is changing the statute to target what it perceives to be misuse of that factor.
Well, let me interrupt to pick up on Judge Schenker's question about the difference between the original sentence and resentencing under IRA. In my day job, when I sentence people who are less than 25 when they committed the offense, and regardless of whether I end up imposing a sentence of 15 years or more, I take into account factor 10, the hallmark factors of youth, all those things. I frankly think I have a responsibility to do that. What makes the original sentence different from resentencing under IRA in that respect? How is the judge's obligation in resentencing or in the original sentencing any different than what it is at resentencing?
So I think at resentencing, we're taking the temperature at this point in time to establish whether rehabilitation has happened. And I think that what factor 10 says is at this point, because we're looking at rehabilitation, these are all serious offenses. These are exclusively offenses that have caused serious harm for which people have served lengthy terms in prison, and lengthy is 15 years, the council says. So the council has made the decision that 15 years is enough time for this special category of youthful, less culpable people to have a chance to demonstrate the maturity and rehabilitation and have a chance to get out. So I think that's how it differs. I think that at the initial sentencing, that time hasn't passed yet. There hasn't been an opportunity for this person to demonstrate, what they have had a chance to demonstrate over 15 years. And so IRA that is what factor 10 is getting at, and that's why it's mandatory and categorical. And why we think that, by saying culpability is not something you're supposed to be weighing up and down here, that is the same as saying retribution and whether this person deserves to serve more time, even though they are not dangerous and rehabilitated. That is a consideration the judge should not be considering. I'd like to point to Bishop, the language in Bishop, and I think the language in Welch too. Okay, this is the facts of this case. Footnote 2 in Welch says, the court says it doubts. We doubt that reference to victim opposition could be the sole, and that's emphasized, support for a trial court's finding that release is not in the interests of justice. I think that that's a point that the government, when it cites Welch, has been not acknowledging, and I think that goes hand in hand with the language in Bishop, talking about how the council has so deliberately de-emphasized reliance on the nature of the offense as a reason to keep people locked up. I think those are the facts we have here. And I'll point, to, I think in support of that, it is entirely possible that victims, they have a variety of viewpoints in any case, but it's possible that victims could come into court and oppose the entire project of IRA. They could be philosophically opposed to any second look sentencing, and they could say that in court and say, this caused me harm. I don't think anyone should ever be released under this sentence. And I don't think that could ever be, I don't think there's any disagreement that that's never going to be something that allows a court to disregard the legislative enactment.
Well, I agree, and I know you've gone over your time, so this on me. I agree with you that while the views of the victims deserve serious consideration, they can't be dispositive. But isn't the reason why a sentencing judge considers the impact of the crime on victims is because that's relevant to what you called retribution. The more serious the impact, the more punitive a sentence is warranted, the greater the need for deterrence of future crimes. You don't consider the impact on the victim as an end in itself. It's because it's relevant to retribution and deterrence, or am I wrong?
I think that that's one potential way that a victim impact statement can be used, but it's one among many. And I think that, victims don't always oppose. I think it's a mistake to equate the requirement to consider a victim impact statement with an assumption that those are going to be statements that favor continued incarceration. Some victims don't oppose, and I don't think—
So you can consider the victim impact statement only if it supports granting the motion, but not if it's in the other direction?
I mean, I think that many ways that a victim might describe how they don't oppose and how they have forgiven someone may actually reflect on factors that have to do with interactions that they've had with the petitioner over the course of incarceration, right? There may be, these are very nuanced things. And I think that there are also, as the Department of Justice itself recognizes, there are salutary effects to victim impact statements that are valuable in themselves, apart from extending incarceration. And so, yes, the court has to consider them. It would have to consider them, regardless of IRA, because their victims have certain rights to be heard and to be present. But I think in this statute, we have to interpret these things, interests of justice, all of these factors have to be interpreted in light of, the constraints of this particular statute and its purpose. And I think here, and I think Welch supports this, right? I think this is what Welch says, it can't be the sole support. And here, it's the sole support. The nature of the offense, the harm to the victims, these are serious things in Judge Higashi's eyes. And that's why she did not immediately release Mr. Doe, even though the government didn't oppose immediate release. That was legal error. We think it requires reversal. We think it requires immediate release.
What if the government had opposed immediate release? Would that make a difference in this calculation?
No, I don't think so, because I think that the factual findings are the same. I mean, I think that's another thing that can be taken into account. I mean, they oppose a lot. And I think, and I think that's one of the things that the council specifically called out when it took the nature of the offense out of the statute and added the language to C10. It said the government has been opposing all of these, and it's been relying on the nature of the offense, to argue against release of rehabilitated people. That's not what the statute's about. The statute is about releasing people who can show their rehabilitation, whose further incarceration is not in the public interest.
All right, thank you.
Thank you.
All right, we thank both parties for your briefs and arguments, and we'll take the matter under advisement. Our next case this morning is Cameron Witeru, individually and as personal representative of the estate of Okemute Witeru and Agnes Witeru versus Washington Metropolitan Area Transit Authority. Great. Good morning, Council. But before you begin, I just wanted to note for the record that this case involves a certified question of law from the DC Circuit. And for the record, the question certified to this court by the DC Circuit is whether under District of Columbia law and under the facts described, may a plaintiff who has a passenger located on a common carrier station platform involuntarily falls backward from the station platform into a non-public area immediately adjacent to the station platform, and from the impact of such fall sustains immobilizing injuries, may recover for the exacerbation of those injuries attributable to the common carrier's failure to aid him if the common carrier knew or had reason to know of his injuries. So I just wanted to put that on the record. And Counsel, if you're ready to proceed, can you state your name for the record?
Thank you, Your Honor. Andrew Levy on behalf of the plaintiff appellant estate of Okemute Witeru and his parents. I'm joined at council table by my colleague, Michael Abrams, and I also want to, for the record, note that I'm joined by one of my newest partners, Jacqueline Cadman. I would ask that I be allowed to reserve 4 minutes of my time.
Yes.
11 years ago, next month, Okie Witeru a 35-year-old lawyer entered the Judiciary Square metro station, paid the required fare, and several hours later died a slow, painful, and completely preventable death. The question certified to this court is whether the special relationship between common carrier WMATA and Mr. Whitteroo, its paid passenger, continued after he stumbled and fell backwards into an area not open to the public. Had he fallen forward, we would not be here, where there would be no question that if WMATA knew or should have known of his distress, it would have had a duty to provide assistance. Can it be that WMATA's duty turned on the happenstance of which way he had the misfortune to fall when he stumbled?
So the Supreme Court said in the Britt case almost over a century ago that landowners are generally entitled to assume that people will not trespass. Was WMATA entitled to assume that people wouldn't end up in non-public areas like the trough behind the parapet?
My answer to that question, Your Honor, is it doesn't matter. This is not strictly a question of foreseeability, which is to say, just as in an attractive nuisance situation, we might call the child a trespasser. The attractive nuisance doctrine is an exception to that.
But what about, with respect not to foreseeability, but the duty to inspect? Did WMATA have a duty to inspect other than one arguably arising from its operating policy to do hourly inspections of the station?
So the question is whether WMATA, if it knew or had reason to know under under the restatement, would it have a duty to provide aid? That's not my question. I'm sorry to interrupt. I apologize.
There's discussion in the briefs about a breach of a duty to inspect. And my question is, what is the source of that duty? Is there a source of that duty other than the WMATA operating procedures that required hourly inspection?
I understand the court's question, and the record reflects, and the district court did find that both WMATA's internal operating policies and the national standard of care that applied to WMATA's conduct both required hourly inspections in which the station manager was required to specifically inspect areas where a package could be hidden or a person might hide or otherwise be found. So this is one of the reasons that we argue that there should be liability in this case, or that a jury should be allowed to assess that, is that there's no addition.
My question is, does the failure to adhere to that policy, two questions again, does it rise above the level of negligence? And two, while it might breach a policy or a procedure, how does it give rise to a duty under tort law to the person who might be trespassing in that area?
Because of the special relationship that exists between Mr. Whitteroo and WMATA. This is not, so more than one thing can be true at a time.
Well, so are you saying it's not, passenger and trespasser are not mutually exclusive?
That's exactly what I'm saying, Your Honor. That these are two separate torts. The fact that this is different from the cases where this court and the DC, the federal courts have found that some action on the part of the plaintiff barred the claim for the initial injury. So here, where you have a claim not for the initial injury, but for the failure to to come to the aid if WMATA knew or should have known of the need for the rescue at the very time that that was needed is the basis for this claim that being in this restricted area ought not in and of itself bar the claim.
If Mr. Witteroo had looked over the parapet and thought he saw a cell phone or piece of jewelry, jumped down, suffered exactly the same injury and the same horrible lingering death, what would there be liability? Because then if he intentionally jumped down into the truck.
I don't know the answer to that question, and that's not this record, Your Honor. And the court need not go that far in order to find for the plaintiff in this case, which is to say there is no dispute that this was an inadvertent fall.
Right, but in the other direction, in terms of not needing to reach it, we have sort of implicitly reached it, or at least the restatement which we've adopted has, which is to say that it has not drawn a distinction between the person who jumps onto the tracks and the person who slipped and fell into the tracks. So wouldn't that suggest that Judge Epstein's distinction also is dubious?
I think that's correct, Your Honor. The question, I think both of these questions are answered by virtue of the fact that this is not a claim for the original injury. So all of the cases, certainly all of the cases where an individual went down onto the track, Hines, Johnson, Whitaker, those were for an original injury. So if we really believe this needs to be analyzed essentially as two separate torts.
Well, my hypothetical doesn't involve the first question. I mean, in my hypothetical, Mr. Witteroo made a decision to jump down there and assume the risk that he would land wrong and get hurt.
So here's the difficulty I have with we thought a lot about that, and on the one hand, the answer should be that it boils down to whether WMATA knew or should have known. The only difficulty with and the potential distinction between the hypothetical Your Honor poses and this case is that in the track cases, there is, in addition to the fact that that those were all claims for initial injuries, the other distinguishing factor, Your Honor, is that there is an element of forfeiture or waiver that in choosing to go down onto the tracks or go into these areas that obviously were off limits, that whether analyzed as assumption of the risk or contributory negligence or forfeiture of the special relationship, there is intuitively a reason to see those differently.
Counsel, can I pick up on this because there is, in my view, some intuitive difference between Mr. Witteroo, who is lawfully a passenger, undisputed, when he comes into the station, standing on the station platform, leaning against a parapet that is on the station platform, who accidentally falls backward into an area that not necessarily viewed as ominous as falling forward onto the train tracks. I want, if you could, to focus you a little bit on what the significance in your view is that you're focusing on subsequent damages for failure to intervene or mitigate as opposed to the initial injury, and why that takes this, I guess, arguably, in your view, out of the realm of trespasser. Because on the one hand, the purposeful nature of a lot of the cases like Whitaker, where the person is on the tracks, they walked onto the tracks for different reasons. the purposefulness doesn't exist here with an accidental fall. And I think sometimes we focus on the language of restatement 329 that says, doesn't matter if they're inadvertently, accidentally in an area that's off limits, there's still no duty to the owner or the common carrier. But I'm wondering if that's the same kind of, that language applies in a case here where there's complete accidental falling backwards, and then no discovery over a 4-day period in an area that is so close to the platform where the common carrier would otherwise normally have a duty of some sort.
Okay. By the way, one of the reasons for the delay was the station was closed over the weekend, so it wasn't until the following week. But that's obviously not Your Honor's question. I would refer the court first. I think Your Honor is exactly right, and I would rely for that on the fact that when you look at the commentary under 314A, the language it uses is that it takes it takes the case out of the general rule. Now, the general rule it's talking about is the ordinarily no duty to come to the aid of a stranger. But we believe it is applicable in this case in that the general rule is that the only duty owed to a trespasser is to a known trespasser. But here, where it's undisputed that there is this special relationship, there's no reason that the whole rationale for ascribing this duty in this special relationship, all of the reasons that the common law and the restatement create this duty in this special relationship, all of those continue to apply in this case. That it was this
Counsel,
was.
It seems like
Could you finish that point?
Sorry.
I'm sorry. All those apply here. Why?
Because you had the whole reason for the duty in this special relationship is it's first an economic relationship. The individual was invited by the landowner, and in the case of both innkeepers and common carriers, the rationale behind 314A is that here the rider, the passenger, is relying on the care and the control that the common carrier has over the environment. This is why in a case like McKetchin, where the special relationship had not yet been created and the individuals were not yet on the property of WMATA, there was found to be no liability. So again, all of the rationales, all of the reasons that this special relationship creates this duty, they all applied here. Nothing changed, and therefore, where there's no additional burden on WMATA, it's already required by the standard of care and its internal policies to do these inspections, and where according to WMATA says, well, it shouldn't be, we shouldn't be, should have known, it should only be actual knowledge. But that would create these incredibly perverse incentives such that, Your Honor, the more negligent WMATA is in failing to adhere to the standard of care, the better off it is.
Well, I don't know if WMATA is making that argument. I think they're accepting I mean, I'll let them speak for themselves, but they're accepting a should have known standard, but they're arguing that's not met by negligence. And so should have known might be somebody was waving their arms and could be seen on the camera, or somebody yelled up to the station manager, come down here and help. And that satisfies should have known. And I'm not sure I mean, this isn't before us factually, but I'm not sure we have that here, at least on the undisputed facts.
Your Honor, I think you will hear from my friend, Mr. Shaw. This is not our first rodeo. We've been around this track a couple times before, that they are arguing for only for an actual knowledge standard. And I'll let Mr. Schock correct me. By the way, the record also reflects that in coming down the escalator, that Mr. Witteroo stumbled and lay at the foot of the escalator for 3 minutes without anyone noticing. He then later got up and fell. But ultimately, the bottom line is, Judge Schenker, that is a jury question, that the district court specifically found that on this record, that a jury could reasonably find that WMATA knew or should have known of Mr. Witteroo's predicament. And I don't know if I have any time to reserve, Your Honor, but with that, I'll turn the mic over.
Great, thank you.
May it please the court, Pratik Shah for Appellee WMATA. The certified question boils down to, in the DC Circuit's words, quote, whether Mr. Witteroo became a trespasser, end quote, after he negligently fell into the off-limits trough.
Can I interject, Mr. Shaw, and ask if you could pick up on in response to some of the comments from Mr. Levy about why, in his view, in appellant's view, this scenario falls within the exception carved out in the restatement 314A. Why, and in fact, it is quite similar to the illustration in the comment 1 of 314A, sure. Where the restatement says under that circumstance, there would have been an obligation, a duty on behalf of the common carrier to render aid. Why are we not within that exception here?
So the reason we're outside of 314A's special passenger status and in 329's trespasser status is because of Mr. Witteroo's entry into the off-limits area, the trough, which is clearly, everyone here agrees, undisputed, right? Nobody is welcome in. It's closed to passengers. This area 4 feet beneath the station platform, behind a wall housing electrical and lighting equipment, where the record shows no one
is not as obvious as the hazard presented by the train track, but that's a different line of analysis here. Sure. The people routinely lean on the wall immediately abutting the trough. They look down in there. They're very close in proximity to it. But I digress. I'm sorry.
Right. Yes. So the difference is that once he has entered that area, he has become a trespasser. That is clear. They accept.
But that's different, isn't it? Factually, from a line of our cases, I'm calling them the train track cases, sure. Where we have examples of a mentally ill person intentionally walking, wandering on, placing themselves onto the track. We have other incidents where people fall onto the tracks in a certain way that seem a little different in some ways.
Your Honor, I guess 2 responses to that. The first response is, I'm not sure they're materially different. If you have someone who's senile, or that's Hines, or Whitaker, someone who's intoxicated, and the court said plaintiff was intoxicated at the time,
right? But he didn't,
and not in control of his action.
He didn't ambulate onto the train direction. His scenario seems closer to me to some of the property landowner cases. For example, the one involving the child at the parking lot of Washington Hospital Center, who falls accidentally into an off-limits area there, where we did not find that they were a trespass and that we found some duty was owed.
Sure.
Walk me through the distinction in your view between those 2 lines of cases. One where there is some obligation by the landowner, property owner, which would be analogous to the common carrier special relationship here.
So assuming that
I know that was six questions in one.
Yeah.
But...
So let me just take it step by step. So I'm assuming in answering this that you think that the senile and drunk passengers in the line of cases that they accept that they say forfeit their status when they enter off limits areas like the tracks. Let's assume that those are distinguishable for the reasons that you said. I think that's debatable, but let's assume that. Then I think the reason there is not a single case out there in any jurisdiction except Hawaii, which has abolished the trespasser rule that we're aware of or that's been cited here, that has ever found a trespasser obligation, the normal negligence obligation to a trespasser outside of a recognized exception in the restatement. So the restatement has in the trespass section, sections 334 to 339 of the restatement, has enumerated exceptions to the trespasser standard. One is the one that you mentioned, Chief Judge, attractive nuisance or children falling into areas. That's laid out in the restatement in the exceptions. If you read the exceptions, there is no exceptions for passengers in that. And in fact, if you go back to 314A, 314A says it's limited that when the passenger ceases to be a passenger, the special duty no longer applies.
So if you put if the station manager had seen Mr. Witteroo fall backwards into the trough, was he free to say?
No, Your Honor. I think if he actually saw them, there's two ways that WMATA could be liable in that circumstance. The first is, right, just because you're a trespasser doesn't mean WMATA is not liable. If they've engaged in wanton, intentional, or reckless conduct.
Well, but we're talking about a duty to aid. Would it be wanton not to aid? I mean, as somebody who WMATA recognized as a passenger,
sure,
to whom they had a duty, had this terrible accident, they could just say,
if they actually saw them, I think the plaintiffs would have a decent argument that that's wanton not to aid them. But if you don't accept that, Your Honor, the other argument is, and this comes straight from DC law and Copeland, it's the first two paragraphs of part 3 of the Copeland opinion. They say it is a different ballgame if the trespasser actually knows the person is in there or has specific.
The landowner knows.
The landowner in Copeland. And so what Copeland says.
Isn't there the duty? Are we mixing 314A exception with 329 trespasser? Because I was wondering why we're not under the 314A exception. And
right. So I guess let me address your question, Chief Judge, and then go back to Judge Epstein's question. So to answer your question is the answer I gave. The reason why we're outside 314 and in 329 is because within the language of 314 has an exception. It says once they've ceased to be a passenger, the special obligation no longer applies. Then, and you've ceased to be a passenger under this court's case law in FERFER when you've exceeded the invitation. Nobody was invited into that trough 4 feet beneath the station platform in the wall. And if you combine that with 329, the 329 example, illustration 1, is directly on point. 314's example goes back to Judge Epstein's questions. 314's example is exactly that. The train operator saw the person fall, right? That's what 314.
But the issue in that case was whether there was a duty to prevent it. The victim wasn't seeking to recover for the aggravation of the injury.
In 314, it was, Your Honor. It says, and I'll just read you the example in 314. It says a passenger on the train of B Railroad negligently falls off the train and is injured. The train crew discovers that he has fallen off, but does nothing to aid him. So that's your example. They actually see him. And in that example, he lies unconscious as a result of his original injuries are seriously aggravated. B Railroad is subject to liability to A for the aggravation of his injuries.
I agree with it. I'm sorry, I thought you were talking about illustration 1 in 329.
Oh, yeah. So that's
329. It wasn't an aggravation of injury.
Right. So what I'm distinguishing 314 from 329, 314, the key distinction is the one you raised. They knew he had fallen off. They saw him fall off. The train crew discovers he's fallen off. That's under this district's case law in Copeland, it says in black and white, and the railroad owes an undiscovered trespasser a duty to refrain from willful or wanton conduct. Once the presence of the trespasser is known, so now we're in the 314A example, the railroad must exercise ordinary care. We accept that, Your Honor. This case, though, it's undisputed. WMATA did not actually know Mr. Whitroux was there. And Judge Shunker, to your question, nobody told them. They had no specific reason to know he was there, which is what the restatement requires for trespass. Someone, they've heard him shout or another passenger has told them, like in 314A. Then you are in, according to the restatement in Copeland, you're in 329. And
okay,
the
now
illustration there.
What would you say to the prospect of a duty to aid not violated solely by wanton, et cetera, conduct, a duty to aid based on should have known? And I know you're saying that negligence doesn't rise to should have known. So maybe that's not the case. But the certified question to me is a little confusing because it's asking us to decide if a duty to aid arises from should have known.
Right. Yes, I think the question is confusing. I think the answer the court can give is that when you have an undiscovered trespasser, plaintiffs cannot recover unless WMATA engage in intentional, willful, or wanton misconduct. It's undisputed in this case that he was undiscovered. And when you're talking about has reason to know in the trespass language of the restatement, and the comments in section 333 and 336 make this clear, what they're talking about is has reason to know not under the ordinary negligence standard, because that would take away the entire point of the stricter trespass standard. It's when you have specific reason to know. So what the restatement says is you see a shape of someone that looks like a body and you ignore it, or another passenger comes and tells you that someone is there and you ignore it.
So that on these facts, as you've I think described them, and I think are undisputed, you should be, tell me if I'm wrong, you should be open. I'm not saying we're going here, but you should be open to a rule that says duty to aid can be triggered to an unknown to a trespasser if there is reason to know.
If reason to know is not the ordinary negligence standard, right? Because that's the whole point. I'm saying. Right. It has to be specific reason to know, either actual knowledge or someone has told you or you see a body. What it doesn't encompass is what their position is. It is their position that WMATA should have known, because if they had done an inspection in the ordinary duty of care under a negligence standard, they would have discovered him. That is plainly what the trespass standard is getting out of. It's not an ordinary negligence standard. You have to be wanton, willful, or reckless. 329 and 314A can be reconciled based on that distinction. 314A is about someone in that example, the train crew discovered that he was fallen, still didn't aid him. 329 is exactly on point with the case here. Without any negligence on his part, it's worse here because he was negligent, but without any negligence on his part, standing on the platform of a subway station of the company, he slips and falls onto the tracks. While there, he is run over by a train of the company and injured. A is a trespasser, and the liability to him is determined by the trespass rules, notwithstanding the accidental character of his intrusion. So, Chief Judge, that goes exactly to your question. Someone who slipped and fell onto the tracks through no fault of their own, the restatement, which this court in Furfer adopted, says, notwithstanding the accidental character of his intrusion, the trespass standard doesn't apply. That doesn't mean WMATA can't be liable, but the trespass standard, which is the question that this court, that the DC Circuit certified, is what is the standard? It's the trespass standard, wanton, willful, intentional conduct, which they haven't alleged.
Tort law generally enforces national standards of care, at least in the district. That's got to be a national standard of care, not a local standard. But what's the harm to society? What's unfair to WMATA if there's a national standard of care that requires public transit companies, providers to inspect stations weekly, including areas that are not open to the public, and somebody suffers from a breach, why is it unfair to hold WMATA liable for
Well,
that?
Your Honor, the whole point of the trespass law and the restatement, which again, remember, this court in Holland sitting en banc rejected calls to relax the trespasser standard. That was the minority rule that the DC Circuit tried to impose on DC. And in Holland, this court said, no, we're sticking with the majority rule. The whole point of that policy balancing there, it's not about wrongfulness, but what they said is it imposes unreasonable obligations on an owner to monitor areas where they have not invited anyone.
I agree.
Yeah.
But here there's evidence that's not unreasonable to impose that duty on owner. There's a national standard of care that requires any mass transit company to do this.
No, so just to be clear, Your Honor, in the record shows no one has ever, there is no evidence in the record that anything has ever been found in that trough behind the parapet wall. That would not, it is very much a disputed fact whether the duty, that national duty that my friend on the other side mentioned, the duty to inspect, it would not cover looking behind the parapet wall into the electrical housing. That is a very much a disputed issue of fact, but that's a disputed issue that is under the negligence standard. And so the court would only have to resolve whether WMATA firmly believes, and it is never believed as part of their policy to look in those areas.
If society has evolved, past the point, decades ago where trespassers were on their own, good Samaritans, tough, you could walk by somebody dying in the street, no liability. If we've evolved as a society past that, and there is evidence that there is a national standard of care, why should tort law prevent that from being enforced?
Again, Your Honor, the national standard of care doesn't require WMATA to look in every nook and cranny of a station. WMATA has over 100 miles of tunnels, over 100 miles of tracks, all sorts of things within their stations. If they had a duty to inspect all of those areas, that would be a massive new obligation. The district tort law has never imposed that obligation. It would be financially unmanageable. It would be practically unmanageable, and it would run afoul of the district's determined. This court sitting en banc kept in the trespasser standard, notwithstanding a minority rule percolating in some jurisdictions that tried to do exactly what you're saying, Judge Epstein, to relax the standard. This court said, no, we're sticking by the majority rule. It would be if this court were to go from scratch and try to use policy to dilute the trespasser standard, we're talking about massive new obligations
Mr. Shaw,
on WMATA.
I want to take you back to what I view as some of the ambiguity in the certified question, and why I'm still stuck on the 314A exception side. I know you want to push me back over to the 329 trespass side.
Sure.
But when we get to the 314A exception, and the certified question talks about whether the WMATA knew or should have known, why? I hear you saying actual knowledge.
Yes.
And I don't think that there's an actual knowledge requirement on either side. Now, it may not be as explicit as it is in negligence, knew or should have known with reasonable efforts, as we might describe it under the negligence side. But aren't we talking about something different here for these purposes?
Two responses, Chief Judge. One is the actual knowledge requirement comes from this court's case in Copeland. Here's what this court says.
Which was the trespass case.
Trespasser case.
I'm on the 314A side, but go ahead.
Okay. Well, if you disagree that he's a trespasser, then we lose the certified question. But if you're talking about, there is a recognized distinction in this court's binding case law between discovered trespassers and undiscovered trespassers.
Well, but it wasn't, the reason we're here on a certified question is because that is not clear in our case law, or at least for purposes of the DC Circuit's decision. So they've sent it back to us to look at.
Go ahead. Sure. There may be other things that are unclear, But what is clear
Well,
is this court, there are other questions that I agree.
If we were to agree that Mr. Whitteroo was a trespasser, that point is clear.
Right.
But I guess we're here because the DC Circuit is not clear
Got
from our trust case law
Yes.
whether he should be considered a trespasser or not.
Right.
And so this is why I think there is perhaps a little more tension than you recognize in your argument between 314A as an exception to the general rule of common carriers, of which WMATA is, and the 329 restatement sections dealing with trespassers.
Sure, Your
So
Honor.
I may still need a little more
Okay,
persuading
so-
as to why he's a trespasser.
Right. Okay. So back to the 314 question. I'll put the known versus unknown because that's relevant once he's a trespasser. So I'll put that to the side. So why does he belong in the 329 and not the 314 box? So I guess a couple answers. The first one is looking at those two on point. The one they say is on point, their example in 314, our example in 329, which we say on point. The difference between those two examples, as I read you, is the example in 314 is the train crew discovered him and still did not aid him. In 329 is like our case. They did not know he was there.
Okay.
So if you're looking to reconcile the two examples, that would be the distinction. And it's the 329 example that describes this case. So that would be, I guess, first reason I would argue, look, obviously they're not crystal clear, right? They both overlap. But if you had to choose I think the question here is which is the better answer, right? And so I think that distinction is a material one that Copeland, I won't talk about Copeland now, but Copeland recognizes that as a material distinction. The restatement recognizes it as a material distinction. This court has adopted the restatement. And so I think this court should recognize it.
Both of them.
Pardon?
We've adopted both.
You've adopted both of them, but this court in what those sections say is there is a distinction between someone who you know is there and who isn't there. And so that's what those two examples are doing. So that's the way I think, that's one way you would reconcile it, right? Is say, look, the 329 example is more on point here because they did not actually know he was there, or if you will, have specific reason to know from someone telling them. That's one way to reconcile them. The second way to reconcile them, if you don't want to rely on those examples, is the actual text and structure of the sections. 314 applies to passengers, but it expressly carves out. It says, once you've ceased to be a passenger, no longer get that special status. Meanwhile, 329 has the trespasser status, and it has a group of exceptions, 334 to 339. It enumerates attractive nuisance, the child, the things that you mentioned. What it doesn't have is any exception for a passenger. So if you reconcile 314A saying once you cease to be a passenger, and what Furfer says, again, this court's decision in Furfer says you've ceased to be that was an invitee. You've ceased to be an invitee once you've exceeded the scope of your invitation. That's exactly what happened here. He exceeded the scope of his invitation. Nobody was invited to be in the trough. So what Furfer says, you've now ceased to be a passenger. You're outside 314. And you're not in an exception to 329, which enumerates a section. So if you're just doing a text and structure analysis of the relevant restatement sections that this court has expressly adopted, the better answer is Mr. Whittrue falls on the trespasser side of the line. If you just try to reconcile the on-point examples, Mr. Whittrue falls on the trespass side of the line. So those would be I think my best answers as to why.
Shaw,
yeah.
Sorry, you seem to be suggesting it's a flow chart, a fork in the road, passenger on one side, or maybe, you are a passenger and then you cease to be a passenger.
Right.
You've got a separate path. I asked your friend on the other side earlier if his argument rests, I don't want to put words in his mouth. I believe he said, and he can correct me in rebuttal, that his argument partially at least rests on the notion that these concepts are not mutually exclusive. And I think that the argument would be, we're making law here, basically. We're a high court. We can say that in the unique circumstance where someone was a passenger, so now we're out of Copeland land, right? Someone was a passenger. They, through lack of any volitional act perhaps became what could be described as a trespasser, they are simultaneously a passenger and a trespasser in some philosophical sense. And so therefore, some duties might apply. I mean, what's your response to my inartful framing of that argument?
Sure. So I guess two responses. First is there is no case from any jurisdiction that anyone has cited or that we're aware of that's ever said you can be both at the same time. There, on the other hand, there is a mountain of cases that say once a passenger has entered into a restricted area, they become a trespasser or treated as a trespasser. So there is just no support for that sort of made up rule. The second response I would have, Your Honor, is that's not how the district court, Chief Judge Boasberg, said passenger trespasser. The DC Circuit, in their certification opinion, here's what they say on the first page of their opinion. We conclude that Whitrew's status, passenger or trespasser, determines WMATA's duty of care. So the DC Circuit, in teeing up the question, told you it's one or the other, and then they come back at the end of their opinion that says, look, if he is a passenger, then the one set of duties apply. But if he is trespasser, the common carrier, quote, owes him only the duty to refrain from intentional, willful, or wanton misconduct. So that's how it's been litigated. That's how Chief Judge Boasberg read this question. That's how the DC Circuit read this question. That's how every case that's been cited to you in these briefs, every case, there's not a single case they can point to of an unknown trespasser entering a restricted area, passenger or not, in which the court has ever found negligence liability. Every single case finds that they are owed the restatement wanton, willful, or reckless standard. They cite two cases. One is from Hawaii, which no longer follows trespass rules, minority jurisdiction, and one is from Massachusetts. Both of those cases involve known trespassers. The owner knew he was there, knew the person was suffering, and didn't aid him. That's under Copeland, that falls in the negligence box, not in the trespasser, willful, wanton, and recklessness standard box. If there are no further questions, Your Honor.
All right, thank you.
Thank you.
May it please the court, in answer to Judge and Shanker's question in the very last answer, Mr. Shah leaves out the Harris case from the DDC. That was the case where a would-be passenger entered a metro station after it had closed. And the court held that there was still a triable issue with respect to whether he should be granted passenger status by virtue of various actions by WMATA. So that is certainly a case where one could say both occurred at once. Very quickly, if I can, the record in this case, Judge Epstein, is that the national standard applied, that was the standard of care, that it dovetailed with, as it happens, with WMATA's internal policies, and that it required the station manager to walk the entirety of the public part of the station each hour and at closing time, and to specifically pay attention to places where a package could be hidden or a person could hide. And the station manager in this case testified that she could not remember whether she had done those hourly inspections. And from that, the district judge, Ketanji Brown Jackson, found that there was a jury question on on whether the standard had been adhered to, and if not, what it would have, but for that, would Mr. Witteroo, who, remember, not only could be seen, but the medical testimony was that he still, for at least the first couple of hours after his injury, could have cried out. So the jury could find that even if he couldn't be seen, he might have been heard. But again, that's a jury question. And at a jury trial, WMATA will have the opportunity to make its 100-mile of tracks argument, and that no one has ever been, the record doesn't reflect whether anyone or anything has ever been found there. But it may also be that if he's correct, that that nothing has been found. It may be because they just don't do these inspections. And I would suggest to this court, as a court of last resort, in a case of first impression, that for the safety of the traveling public, to extend to WMATA only an actual knowledge, which is the 329 standard. It's not the 314A standard. It creates absolutely the wrong incentive. Again, the more negligent it is in failing to do the required inspections, the better chance it has of avoiding liability in a case like this. That tort law is all about incentive. That is the wrong incentive.
Mr. Levy, I'm not sure if I'm clear under what theory you argue we get to the jury. I guess we're here to decide as a matter of law whether Mr. Witteroo was a trespasser or a passenger. And if you could just walk me through your theory as to...
Our theory is that there are any number of exceptions in the law in which, and the one most familiar to everyone is in the attractive nuisance situation, in which a child is on land in which he has not been invited, he is not allowed. He would meet Section 329's definition of a trespasser, but that the law has recognized an exception that even though he's a trespasser or would be a trespasser, but for other facts being present. So similarly here, Your Honor, our position is that as a paid passenger of a common carrier who does not seek recovery for an initial injury, that 314A would impose on the common carrier a duty to provide reasonable aid, and here that's just calling 911, if it knew or should have known of the distress. That is the standard in 314A. It is different from the standard in trespass, and applies if one comes within this exception, which again, the commentary talks about. 314A takes the case out of the general rule. So it's an exception to the rule that would otherwise apply. And that's why I originally said, not sure in response to Judge Epstein or Judge Schenker's question, more than one thing can be true at a time. And we think, was he a trespasser is the wrong question. The question is, once he was in need of aid, and I guess I would leave, we cite in our brief, or we note in our brief, the example of an innkeeper, of a guest, and the innkeeper standard is the same 314A standard, of course. If a guest of the hotel fell into a fountain in the hotel and needed help, clearly that's not somewhere that guests are invited to be. But the idea that at that moment when the guest is most in need of aid, that the innkeeper would have no duty if they knew or should have known of the need is preposterous. And it would be bad. We respectfully submit it would be bad law. And what I guess this court is really, the question I would respectfully submit to your honors is, in dealing with a doctrine which had its origin in 19th century England and baronial estates, where it was recognized that it would be unreasonable to impose on a landowner the duty of reasonable care with respect to such trespassers, whether in this day and age, given the existence of 314A, given the fact that there's no additional burden to WMATA by imposing this new or should have known, that it would be, quite frankly, bad law to extend 329, to hold that 329 applied that standard applied to the exclusion of any exception, any other facts. And the court, I would submit, can do so perfectly consistent with existing law and in a way that does justice in this case and protects the traveling public.
Thank you.
Thank you, Your Honor.
We thank both counsel for your briefs and arguments today, and the matter is taken under advisement. All right.